Due Process, winner of 10 Emmys, including a 2007 Mid-Atlantic Emmy for in-depth reporting.
No point in having an organized bar unless the organized bar is ready to stand up for the rule of law.
He argued the case for detainee rights, and the U.S. Supreme Court agreed. But Guantanamo was just the latest mark in a legal career that spans 6 decades. Judge John Gibbons and the pro bono work that makes him unique. Up next on Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
It was Richard Nixon who named him to the federal bench, and yet he's become one of this country's foremost liberal voices. The former chief of the Third Circuit U.S. Court of Appeals, John Gibbons, continues to make his mark on a wide range of controversial causes, from gay marriage to Guantanamo, from the rights of convicted sex offenders to the fight against capital punishment. I'm Sandra King in Raymond Brown's chair today for this special edition of Due Process, because it was Raymond who had the privilege and the pleasure of an intimate, in-depth sit-down with the revered Judge Gibbons.
Sandy, it was a great conversation that took us from his modest beginnings to his heady years as one of the most important jurists in America. When Judge Gibbons retired from the bench 18 years ago, his old friend Justice William Brennan said the mark he made on those who knew him, on the court he served, on the fabric of the law, goes very deep, and it will last long. How interesting then to learn how unlikely his law career really was. Did you have any interesting postings while in the Navy?
Oh, I did indeed. The most interesting one, of course, eventually was Guantanamo, but after midshipman school, I went to the Bureau of Ordnance, and from the Bureau of Ordnance to the Ordnance Facility in Guantanamo Bay.
And in a moment, we'll have a chance to perhaps expound on the irony of your Guantanamo posting. After the war, the GI Bill takes you to law school.
Yes, and actually, initially to finish my undergraduate degree and then to go to law school.
Now, how many lawyers did you know before you decided to go to law school?
None. I had never met a lawyer. As a matter of fact, when I first was choosing which law school to go to among a number where I had applied, my father introduced me to the general counsel of T. Ballantyne and Sons, where he worked, and said you ought to talk to him about which law school you should go to.
When you got out of law school, this is Harvard Law School, there was a guy named Brendan Byrne in your class at law school?
He was indeed.
An unusual class in terms of its impact on New Jersey.
Yes.
And what did you do when you came back from law school?
Well, first of all, between my second and third year in law school, I clerked at McCarter and English. It was McCarter English and Studer at the time. And of course, we then had the mandatory clerkships before you could take the bar exam.
Was that a good system, by the way? We've interviewed my dad, who talked about his clerkship for a year. Was that a system that enhanced the quality of lawyering or not?
I don't think so.
It sounds almost like apprenticed or indentured service.
It was a way of discouraging people from entering the profession.
Interesting.
I never thought much of it.
Now, over the years, you became active in the bar to a point where you became state bar president.
Yes.
That would be around 1967.
I became president in 1967.
And in Newark, there was an epiphanous event, an event that maybe changed the course of the history of this region.
Well, it certainly changed the history of Newark. The 5-day conflagration was a momentous event in the history of this city.
Some call it riot, some call it rebellion. I guess it depends on...
Yeah, it depends on who's doing it.
That's right.
The police all call it riot. The rioters all called it rebellion. Frank Vecchione and I were out in Vancouver, British Columbia on business, and we flew into Newark at dusk and saw the city burning. It was a horrendous experience just to fly in and see this and get on the ground and be told that we can't go to the office, you got to go home. The downtown area is not safe. We're not letting anybody in.
Now, what did you do as bar head in terms of the question of the rule of law and what happened to it during that time of great conflagration?
Well, about the third day or so of the riots, the TV news was then in more or less its infancy, but there was a lot of coverage, and I learned that the authorities had about 1,500 people detained, not in the Essex County Jail because it didn't hold that many people, but in places of detention around the county, like armories. Most of the detainees were being held for curfew violations, picked up going to their night job. I approached the acting assignment judge, Lawrence Whipple, and said, something has to be done about that. So Whipple convened a meeting with representatives of the Attorney General, of the State Police, and the National Guard, and the Mayor's office in Newark. And Hayden and I made our pitch that these detainees had to have access to the judicial system. The authorities were having none of that. Their answer was, we're trying to restore order in the streets.
That the American people, I think they're pretty tired of this cloak of civil rights activity shielding this criminal activity.
We can't spare the personnel to transport people to the Newark jail. And Judge Whipple, who of course was a former county prosecutor, hardly soft on crime, leaned back in his chair and he said, well, can you spare enough people to transport the judges to the places of confinement? And of course they had to say yes.
Now, some folks might look at that situation and say, well, you were insisting on some technical requirements that people be brought before a magistrate. I'm assuming that you believe there was something more fundamental at stake, even though the authorities were consumed with order in having people incarcerated with no appearance before a judge.
There is something very fundamental about that. Access to the judicial process is the core value of the American system. Everybody is entitled to access to the judicial process and prompt access. Otherwise, you have situations where people may be detained for years without access to justice.
And we're going to come back to that because maybe that issue arises in another context. Yeah. But is that something that should be done by the head of a bar association? I mean, is that quintessentially what bar leaders should do under those situations of crisis?
Absolutely. There's no point in having an organized bar unless the organized bar is ready to stand up for the rule of law.
Now, you had subsequent exchanges with Governor Hughes about what had happened. Did he have a different position in principle, or was it a different kind of discourse?
No, it was not a difference in principle. I think that he inherited a situation in Newark that got out of control before the state authorities even got involved. And the indication that he was not the least bit offended about the organized bar standing up for the rule of law was that when it came time to appoint a commission to study the causes of the civil disturbances, he selected me as one of the members. We'd hoped it would have an influence, and I think it did.
Now, in '69, you were appointed to the federal bench by President Nixon.
Yes.
You had a long and distinguished career on the federal judiciary, and this is a very unfair question, but are there one or two opinions of yours that stand out in your mind as most pleasing to you, either in terms of the result they reached, their judicial impact, or the artistry of the opinion itself?
No.
No, okay.
The reason for the no is, had you asked me this 19 years ago, I might have had an answer. But
what would your answer have been 19 years ago?
19 years ago, it might have been my opinion as a temporarily assigned district judge in the Edgar Smith case, because I was called upon to do a job that required me to stick my neck out a little bit.
Was this a reward?
No, it was a favor for the Chief Judge of the Court of Appeals.
And Smith was, of course, a cause célèbre. William Buckley had taken an interest in his case.
Yes.
And he was a person who had been convicted of murder, but circumstances raised legal issues.
He went on trial for murder, but before the trial was over, he pleaded after they admitted his confession. And what interested Buckley was that he contended his confession had been illegally coerced, and that therefore the guilty plea should be set aside.
And how did you rule when the case came before you?
Well, I heard the testimony, and I said yes, there had been a Fifth Amendment violation. He had been subjected to coercive examination, and the confession should not have been admitted in the trial.
Now, were you treated gently by the press for releasing or siding with this murder on technical grounds?
No. The Newark News had 4-inch headlines.
Okay.
Smith released.
How did that feel as essentially a baby judge to have early in your career a case you've decided on legal principles and to be castigated publicly for it?
It didn't bother me because federal judges have life tenure. They couldn't do anything about it. They certainly weren't going to impeach me for a decision.
Do you think, as a general proposition, that the public conversation about what judges do involves understanding of the principles you have to apply, or is it usually a different kind of conversation?
Well, that varies from time to time, depending on the political climate. All right, right now, I think it's fair to say that the national administration is uncomfortable with some of the recent decisions by the Supreme Court. And some of their supporters are equally so. But
well, let's get to one that you had a hand in. You told us about service on Guantanamo during the war. Rasul versus Bush, which is an important case having to do with Guantanamo. Tell us what Rasul versus Bush was and why that's important, if it is important.
Well, Rasul versus Bush involved two great groups of detainees, some Kuwaiti nationals and some British nationals, who had been picked up in Afghanistan or Pakistan. In some instances, we suspect, had been sold to the Americans by bounty hunters. The D.C. Circuit held that no American court had habeas corpus jurisdiction to release these detainees because Guantanamo Bay, although occupied by the United States under a perpetual lease, was not American territory. And therefore the writ of habeas corpus didn't reach these people. And a large number of lawyers around the world were outraged at that. And there were amicus curiae briefs filed on behalf of...
That was a friend of the court brief,
yes,
filed by people or organizations who care about the issue but are not parties.
Yeah. One of the people who filed an amicus brief was Mr. Korematsu, who had, as an American citizen, young person been detained during the Japanese War. He was a Japanese American and was locked up and brought a petition for habeas corpus, which ultimately the Supreme Court of the United States rejected. And of course, it was the Korematsu case that the government was principally relying on.
Now, you argued Rasul before the Supreme Court.
I did.
Did you have occasion to make reference at all to your personal Guantanamo experience while making that argument?
Oh, I did. And I said, from personal experience, I can tell you who's sovereign there because I spent a year there. Justice Ginsburg responded, you don't need to rely on your personal experience there. I can read the lease.
To the extent that there's a core principle involved, is there a connection in terms of that principle between what you did in the connection with the Newark conflagrations and the Rasul issue in terms of?
Oh, absolutely. It has to do with the vital necessity that the legal profession preserve access to the courts because we can't preserve the rule of law otherwise.
What's the death penalty like as an issue for you?
Well, the death penalty as an issue for me has always been an issue. Ever since I was in grammar school, there are a lot of other reasons why the death penalty is inappropriate, and its misuse on racial grounds has been a prime feature of American jurisprudence for a long time. But it's more fundamental than that for me. Society simply does not have a moral right to exact vengeance. And the only other rationale that's been advanced is deterrence. And the idea that certain crimes of passion are going to be deterred by the threat of death penalty. There's no social science support for that at all.
I guess we could touch lightly on the fact that among your other appearances before the Supreme Court was in the context of a death penalty case, again, coming out of Virginia.
Yes. You know, there was a Virginia case called Williams v. Taylor, and the arbitrariness of the death penalty is well illustrated in Virginia. In Northern Virginia, you don't get many death penalty prosecutions at all. In Southern Virginia, you get a lot. We know that over 112 death inmates awaiting execution have been found to be actually innocent of the crimes of which they were convicted. The idea that retribution by death, which is a synonym for vengeance, is an appropriate remedy for any civilized society. It has always offended me.
Let me, before we get too much into that, make sure we talk a little bit about the Gibbons Fellows, because that's something that I think is important to you.
It is indeed.
And what is that?
Well, it originated after I left the bench. Michael Griffinger approached me and said, we're thinking of starting a fellowship program in the firm where we will have at least 2 people a year working exclusively on a pro bono basis on issues of constitutional law in particular, and on public
and in New Jersey,
issues.
almost everyone knows of the fellow's involvement with Megan's Law.
Yes. Well, this was an offer I couldn't refuse, obviously, and I did come back to the firm. I was also teaching, but and Megan's Law was enacted, and the first Gibbons Fellow case that we took on was a challenge to the constitutionality of Megan's Law. We've litigated it for years and on various grounds, and went through various changes, not successfully. I mean,
But it's important to bring those challenges notwithstanding.
Yes. Yeah.
Let me ask you a question about the current Supreme Court. I've never asked you a political question ever. We've always talked about the law. I think people would assume that your political philosophy is liberal. If that applies to courts, people sometimes say, why would a person we think of as liberal have supported Clarence Thomas and Justice Alito in their confirmation processes?
The real target for many of the somewhat vitriolic comments on the nomination is less him than the executive branch administration that nominated him.
Well, that's an interesting question, and of course, it's personal. Justice Thomas, I knew him very well because he and I served as trustees of Holy Cross College together for years. And the rap that the more liberal press was putting on him was that he's dumb. He doesn't have the intellectual capacity to do this job. And I knew better than that.
Has he disappointed you, not in terms of his intellectual capacity, but in terms of rulings and substantive opinions?
He has rarely written an opinion that I approve.
We're drawing to the end of our conversation because we could talk for hours. Justice Brennan wrote a wonderful tribute to you in 1990 in which he talked about your fidelity to the rule of law. And yet in our conversations we've talked about authorities here in New Jersey essentially denying access to the courts to hundreds of people and what continues to happen in Guantanamo. Are you optimistic about the continued adherence of this country to the idea of the rule of law, or pessimistic?
I'm optimistic.
Why are you optimistic?
Well, one source of my optimism is the way the bar from the biggest law firms in the country have rallied around this Guantanamo detainee issue. Originally, when we started litigating it, a small number of lawyers were involved. Now there must be 50 from the biggest and most prestigious law firms in the country who feel that we must preserve the rule of law.
When we do these in-depth talks with great New Jersey legal voices like U.S. District Judge Robert Carter or Governor Brendan Byrne or my dad Ray Brown, we usually allow them to speak for themselves.
But Raymond, for the reticent Judge Gibbons, we thought it only fair to give a final word to Gibbons' protege and partner, Larry Lustberg, to say some of the things that the judge would never say about himself.
Well, the fellowship was and is one of the most wonderful pro bono programs in this country. Originally a 5-year program, it's now been around for 19 years here at Gibbons. And it is a program whereby 2 young lawyers come here and spend all of their time doing important public interest and constitutional cases. I was the first Gibbons Fellow and started it, and since 1991 or 1992 I've been the director of the program, so I supervise the fellows along with Judge Gibbons. And I think it's amazingly, considering all that he's done, it may be the thing that he's proudest of. So over the years we've done a tremendous amount in the death penalty area. We've done a lot on behalf of women who are victims of domestic violence. We've done a tremendous amount of work on the Guantanamo and civil liberties related issues in the wake of 9/11. We've represented poor people in consumer fraud cases, in welfare reform cases, and a whole variety of issues that have to do with public interest law and constitutional jurisprudence. So at the age of 83 or 84, however old he is now, he's still at it, and still doing it with the same enthusiasm and the same commitment to justice as he has had ever since I met him in the mid-1980s. When he argues in the Supreme Court in favor of Guantanamo detainees or for a particular death penalty inmate, as he has done, those are big cases and people care, and you know, this focuses on him. But even in the smaller cases, the ones that no one has heard about, he treats them all with that amount of care and a sense that the clients are special and that the cases are, in fact, the most important cases in the world.
And back to the late Justice Brennan on John Gibbons. When the dark night of cynicism and hopelessness is on us, we can say yes, fidelity to law is possible, is worthwhile, is real.
And on that note, that's it for this special edition of Due Process. For Raymond and all of us here, I'm Sandra King. Thanks for watching.
His thoughtfulness, just his brilliance. I mean, I think that would take it all in. His integrity, the causes that he has sought to champion.
Civil liberties, prisoner rights. Last year, he co-chaired a national investigation into prison reform.
There are very few people who have given all of the time and the energy public commitments to helping people, and as a judge, he was an extraordinary judge.
Judge Gibbons was among the few judges in the Northeast to consistently hire African Americans as law clerks.
He's an extraordinary man and a brilliant judge, and I am one of his many admirers.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.